Okay, and we are now live streaming. Awesome. Welcome everyone to our quick lunchtime conversation on what's going on with reproductive access, specifically with regards to Mifepristone. My name is Jennifer Martinez. I'm the Senior Communications and Marketing Manager for Legal Voice, a nonprofit based here in Seattle that does work across the Northwest to work for gender equity and liberation for everyone. So we are just going to have a really quick conversation. I'm going to introduce the two folks from our staff, my colleagues who are going to be presenting to you today. Julia Marks, who is our litigation attorney for Washington State, and Alizeh Bhojani, who's our policy counsel here as well for Washington State. They're going to be talking to you today, giving you some quick updates. If you do have questions for folks here on Zoom or for folks who are joining us on Facebook, please go ahead and drop it in the chat or post a comment, and I will flag those questions for Alizeh and for Julia. And for now, I'm just going to go ahead and pass the mic over to them so they can get started.
Great. Thanks so much, Jen. And thank you everyone for spending part of your lunch hour with us. And thank you to my colleague Alizeh, who is here as our expert on all things policy. So she'll be on hand to answer questions that come up. But we're going to start off with a bit of background and going through some slides, since so much has been happening in the last few weeks that affect how people get Mifepristone and access to abortion more generally. So as I'm sure you know, in the past couple of weeks, there have been multiple major court decisions that affect people's ability to get Mifepristone. The big one that you've probably seen is the decision out of a federal district court in Texas, where a judge there took an extreme and unprecedented step, ordering the FDA to undo its approval of Mifepristone. But another important case is one that was in a federal district court in Washington. So I'm going to talk about both of those. And then in the last couple of weeks, since the decisions came out, or less than 2 weeks actually, we've seen multiple requests for action by the Fifth Circuit and the Supreme Court to put those on hold. And we're actually waiting to hear later today on one of those requests. So I'll talk through those different steps and how we got to where we are and what we think we'll see going forward for access. Okay, so just so we know why we're having this conversation, Mifepristone is an incredibly important medication in the United States. It's been used by millions of people who are pregnant to end their abortions safely. And it's been on the market for more than 20 years. So it's part of a two-drug protocol that tends to be used for medication-based abortion in the United States. So patients take Mifepristone first and then follow up with a drug called misoprostol. So Mifi, as we call it for short, is part of the standard of care used for medication abortion across the country and in other areas of the world too. It's also used for miscarriage management and some other purposes. So while it's an important drug for abortion, it's also just important to have on hand for multiple healthcare needs. So Mifi was first approved in the year 2000, more than 20 years ago. There were quite a few restrictions that the FDA put in place on Mifepristone back when it was approved in 2000. And that has to do with how it can be dispensed, the number of times someone has to interact with their doctor before and after receiving Mifepristone, and other regulations, which were pretty burdensome, but it was still good that Mifi was now on the market and something that people could use for abortion care. Over the past few years, those restrictions have been reduced in number and scope, and that's because it's become increasingly clear as Mifepristone is used that it's incredibly safe, and people can safely use it without having to go through all these hurdles that are in place. So starting in about 2016, we saw some really big changes that made it easier for folks to access Mifepristone. That included expanding who can prescribe it, not just doctors, but other medical professionals. It also included reducing the number of required visits. And then during COVID, the FDA actually announced that it was getting rid of the in-person requirement. So people could get a prescription from their doctor via telehealth and then go to a certified pharmacy or go to their provider to pick it up in person. And this was all through really thorough FDA analysis and action, finding that Mifepristone was extremely safe and that they could take away some of these old restrictions because they were unnecessary and outdated. So that's how we got to 2022, when the Alliance for Hippocratic Medicine filed a lawsuit to try to undo not just the more recent changes to Mifepristone rules, but to undo availability of Mifepristone across the board, across the entire country, by forcing the FDA to undo its approval back from the year 2000. And this is just an unprecedented request and unprecedented action by a district court judge to interfere with the FDA's decision to find a drug safe and to allow it to be sold in the United States. So the case was filed last fall, and the plaintiffs are anti-abortion activist organizations. They targeted this specific part of Texas to get before an extremely conservative judge who has a history of anti-abortion and anti-birth control policies, advocacy, and legal decisions. And they asked the judge to undo the FDA approval itself, arguing that the FDA wasn't following the law about making its decisions. And part of that is also an argument that this old law, the Comstock Act, prohibits the mailing of any tools or medicines related to abortion, and that the FDA's actions violated that act as well. And these arguments go way beyond how anyone interprets the Comstock Act, and also goes way beyond the typical requirements for FDA decision-making. Courts are not supposed to step in and question the scientific decision-making of the FDA, except for in extreme circumstances, and even then, it's very constrained. So for the plaintiffs to argue that the FDA decision-making was flawed, and then for the court to jump into the science that they know nothing about, is really inappropriate and really unheard of. Nevertheless, the plaintiffs were successful because they did have this judge who had a clear anti-abortion agenda, who really wanted to find a way to find Mifepristone should not be on the market and to restrict the access to Mifepristone across the whole country. So less than 2 weeks ago, the judge in that case in Texas issued a preliminary injunction, so that's an early order, saying that the original approval was invalid from 2000. And what that fundamentally means is if the original approval is invalid, people can't sell Mifepristone across state lines, people can't import it. There are a whole bunch of restrictions on it that basically will make it almost impossible for people to get. So that was what the Texas District Court was trying to do. Immediately, one of the manufacturers of Mifepristone and the FDA went to the appellate court and now to the Supreme Court, asking them to put this decision on hold because it is such an extreme decision and would have an immediate unprecedented effect of removing an approved drug from the market across the country, which is just something that has never happened. So unfortunately, the Fifth Circuit only agreed to stay part of the decision. So where we are today is that the original approval of the drug still holds, but all the changes over the last 5 to 10 years that make it a little easier for patients to get Mifepristone, those are all on hold because of the district court's decision. Folks have asked the Supreme Court to undo that as well so that we can just be at the status quo where people can get access to Mifepristone. The ideal, right, is that the Supreme Court will stay the lower court's decision so that the full process can happen. They can have a trial, they can do fact investigation, appeals can happen. It's been very fast for this preliminary injunction to make these serious, expansive changes to access to medication without any sort of fact development, thorough legal assessment, opportunity to appeal. So the request to the Supreme Court is to say, let's put this on hold so that we can have a real inquiry here before these changes take effect. This is further slightly complicated by the fact that there's a case in Washington State. I won't get into all the details about the basis for that case. We can address it in the Q&A if folks have questions. But the basic outcome there is that we have a temporary order from a court in Washington saying that the FDA is not allowed to take actions that reduce access to Mifepristone. And this decision came out on the exact same day as the Texas decision. So the FDA is faced with two court decisions from federal courts that say opposite things. One says all your decisions that give people access to Mifepristone don't count. That's the Texas court decision. And the other says you can't do anything to reduce access going forward. So that case was filed by Washington State, but there are quite a few states who signed on. And so for folks in those states, they have this extra layer of protection in this period of uncertainty, where in some places the FDA's actions don't apply. In others, the FDA is not supposed to do anything to restrict access further. So folks in those states should have better access going forward. One thing I just want to note, one of the reasons we have an FDA is to have standardized, consistent rules around medication and information to patients across the whole country. So it truly is unprecedented to see the FDA trying to apply one set of rules in some states and one in others. And the agency is just not set up or structured to have this piecemeal approach to medication, where in one state it needs one label, and in another state it has a different label. In another state, there's an in-person requirement. Other states, there's telemedicine. It's just not even conceived of in the FDA model. So having these competing decisions is creating a lot of chaos for the FDA and medical providers, and of course, patients too, which is the goal of these anti-abortion plaintiffs, to make it hard for people to get access and to even understand the fundamental rights that they have. So with all that legal background, what does this actually mean on the ground? So later today, we're gonna get a decision from the Supreme Court, and they might grant the request for a stay, which just means that we'll go back to the status quo, how it was 2 weeks ago when Mifepristone was approved by the FDA. Mifepristone could be dispensed via telemedicine and by prescribers who are doctors or who are not doctors, but other types of medical professionals. And folks could pick it up at a pharmacy or use a mail order pharmacy. So we have returned to that status quo. However, that's just temporary because the Supreme Court's just deciding the stay, whether to put those changes on hold and keep us where we used to be. The meat of the case, the legal analysis, the factual development, that will still proceed, and that will proceed in the lower courts. So the Fifth Circuit will look at the decision so far and make a decision about whether that was correct, and then there eventually needs to be the full case developed too. So we'll continue to have some uncertainty, but the hope is that getting a stay from the Supreme Court later today would at least preserve the status quo with a fairly high level of access to Mifepristone around the country. It's possible that the Supreme Court will decline to grant the stay, in which case we'll have a very split set of circumstances where states like Washington and Oregon, which signed on to that Washington case, shouldn't see any direct change to access, because the FDA is not allowed to take steps in those states to reduce access. So as I mentioned, the FDA is not set up well for this type of structure, so there is a lot of uncertainty. But basically, folks should still be able to get mifepristone in those states. There could be some issues with supply, because the manufacturers are going to need to navigate this mixed scenario where they are not allowed to sell a certain labeled version of the drug in some states, but they are in others. So there could be some supply issues there. But fortunately in Washington, the governor took the lead on stockpiling mifepristone. So that's good for access. In other states that did not sign on to that case, and in fact, some of them are trying to intervene to undermine that case. In those states, it will be somewhat more difficult to get mifepristone. So mifepristone will still be an FDA-approved drug, but the recent changes, like offering telehealth options and reducing the number of visits you need, those changes won't be in effect anymore. So providers and patients will have to go through those extra hurdles to prescribe, dispense, and receive mifepristone. And again, there will probably be some challenges with the supply chain, as the manufacturers of these medications try to navigate the kind of uncertain and unprecedented situation of having their labels suddenly declared to be invalid by a court in Texas. One other thing to note is one of the more recent decisions that would be on hold if the Supreme Court does not grant a stay is the FDA's decision to approve the generic version of mifepristone. And that manufacturer actually just filed a lawsuit today because they want to be able to continue to sell their drug, and they're worried that the Texas decision, as the FDA interprets it, would completely take their generic version of mifepristone out of the market. So the key takeaways: medication abortion is still available. Oops, let me see if I can go back. And in states where mifepristone is difficult to access, people can still get medication abortion using a misoprostol only option. It's a different way to do it. It might not work for everyone, but it is very safe and effective. So folks should keep their appointments and check with their clinic and their provider to see how they're adapting to this changing situation. And procedural abortion is still available too in the states where it's allowed. So while we might see some strain on clinics, delays in care, and ongoing confusion, care is available and people shouldn't be deterred from seeking it. And so coming up, we'll be watching for the Supreme Court stay, and then next the Fifth Circuit will be deciding more of the meat of the issues later in May. And then we'll be watching these other cases in Washington and the new case filed today in Maryland by the manufacturer of the generic version of the drug. So I think we'll open it up to questions.
Awesome. Thanks so much for that information, Julia. There's so many things going on and just updates upon updates. It feels like we're getting new information daily, even with you mentioned the new legal case filed today. So yeah, if folks have questions, it looks like we have a question in the chat. And so the question, thank you so much, Allison, is the Washington court ruling just as unprecedented as the Texas ruling? Even though the Washington ruling is in favor of access, should we avoid courts setting a precedent of meddling in the FDA?
Yeah, thanks for that question, Allison. So it's definitely an area to be cautious in terms of when courts get involved with agency decisions. So I'm glad you flagged that tension. I should note, though, that the Washington ruling is very different than the one in Texas. So the Washington case is just about a decision that the FDA made in 2023 that's formalizing the decision to allow telehealth back in 2021. So unlike the Texas case, the plaintiffs aren't looking back 20 years, and they're not looking back at many different agency actions that have a lot of long science behind them. So it's much more narrow in scope. And also the Washington court hasn't yet ruled on that question of whether the FDA was appropriate in choosing to change the restrictions that they changed in 2023. They instead, the court just said, let's preserve the status quo. Please don't change anything, FDA. We need to allow this lawsuit to go forward and see if there's any merit to what the plaintiffs are saying. So the Washington court was being very small c conservative, saying let's keep things how they are while we look into the science and determine if it's even appropriate for us to look at the science, which is the polar opposite of the Texas judge who said, I can read science. These were all terrible decisions. Let's throw them out starting in a week. So that's kind of the big difference in the posture and reasoning in those cases.
Thanks, Julia. Really important to get the clarification there. So thank you for that. We have another question in the chat from Jeanette, and it's, if a generic version is brought to the market, what will be the limitations?
I think I'm interpreting your question right, but please feel free to clarify in the chat. So is the question you're asking is if the manufacturer of the generic continues to distribute it, what are the limitations on providers? Is that kind of what you're asking?
Or is it if they bring if a new manufacturer applies for a generic version of Mifepristone, what will be the limitations?
We can answer both. Yeah, so the way that FDA is interpreting the decision so far is that the labels on the medication as currently manufactured is that those labels are out of date. And well, that they're not valid under the fact that the Fifth Circuit is allowing all those recent decisions to be thrown out by the district court. So when a drug has an incorrect label, there are limitations on the ability to sell it and distribute it through interstate. So that will make it potentially harder for people to actually get the drug. That said, those laws are enforced by the FDA and they have a lot of discretion about where they focus their time and energy. So it might be the case that folks are still able to, use, distribute, sell that drug without facing any consequences. But there is a challenge in the fact that the labels that are currently in place on the drugs are going to be out of date because of this Texas court decision.
Thanks, Julia, for answering both kind of approaches to that question. I also want to remind folks, if they are watching on Facebook, you can post a comment on the video there, and we will catch your question there if you have one. But we do have another question here in the Zoom room that we're in. And it states, in medicine, we have peer review and medical commissions, among many other things, governing our appropriate exercise of our license and medical decision-making. Is the only recourse to the bizarre exercise of legal process the courts?
Again, I hope I correctly understand your question. Please jump in the chat if I answered not quite what you're going for. But So ideally, all these issues should just be handled by the FDA without interference. But the plaintiffs have brought this before the courts. And so now that it's in front of the courts, the main recourse folks have is through the litigation process. So that's appealing the decisions up through the Fifth Circuit and the Supreme Court. It's also filing folks with other interests, like the manufacturer of the generic, are filing their own lawsuits because they want to use the power of the courts to protect themselves when these anti-abortion plaintiffs are using the power of the courts to go after their medication and restrict access to people. So we are going to see most of this play out in the courts going forward. That said, the FDA continues to operate, and manufacturers in the future can start separate FDA processes around approval of different versions of Mifepristone. If a worst case scenario, the lower court's decision holds and we see either all of the FDA's decisions on Mifepristone or just the most recent ones undone by the courts, the FDA would be able to go back and redo its decision making and start new FDA processes to get Mifepristone back onto the market. So the Texas court can say the decisions you did in the past were not justified, but the court cannot say you're not allowed to look at this issue again and find new approval and set new restrictions or rules going forward.
And Emily, I feel like I'm sensing a bit of frustration in the phrasing of the question in terms of how this is impacting healthcare providers and how it's impacting access to healthcare for folks across the country. And I just want to reaffirm that it is frustrating. It's, as Julia said earlier, unprecedented. And that in general, the deference is due to the FDA and peer review and allowing healthcare providers to use the standard of care to prescribe care to patients. And so I do want to acknowledge that, yes, it is unprecedented and not based in science or medical fact.
Yeah, thank you for that. And Emily, I saw your follow-up in the chat. I should make more clear, the Texas decision is not grounded in facts or law. There is a standard of review where courts can look at agency decisions, and the court goes way beyond what that is supposed to be. So the court is not supposed to totally replace scientific judgment with its own assessment of science and reporting. There are some limited circumstances where courts do step in and question agency judgment, and that's okay. But this is not one of those times. There's so much strong science and strong reasoning supporting the FDA. And the court was not acting correctly in what they focused on in terms of the science and in how they applied the law about when they are allowed to step in.
Thanks, Julia. Great questions that we're getting here in the chat. The next question that we have is, doesn't this form of attack undermine the FDA and its processes itself and possibly set very bad precedent? Why should companies spend money to go through the FDA process if it can be so easily subverted? And
yeah, that's a great point, Linda. It sets very bad precedent. It really undermines the FDA, and the FDA are experts. They understand how to read medical papers and how to conduct studies and understand studies, and courts do not. And there are times where courts have to look at scientific issues, but this goes beyond that. And the court is really ignoring a ton of FDA analysis and expertise when it makes its decision. It's also another big issue in this case is that the court is disregarding some of the rules about when you can file a lawsuit like this. So it's not only inappropriate on the substance, but the court is going back more than 20 years to say that the FDA's decision was wrong. And under no circumstances should you be able to bring a lawsuit so long after an agency has made a decision like this. So FDA approval, if it's going to be challenged at all, needs to be challenged through the proper channels and in a timely way, not years after the fact for political gain.
Awesome. Thanks, Julia. I think I'm gonna, Alizeh, if you're okay, can I have you bring in a little bit more of like the political policy lens and how that's playing into like this litigation part that we're talking about right now?
Yeah. So I think what folks are getting here and what often is something that comes up in legal processes or in litigation is that the average person or the folks who's not an attorney, who's not a medical healthcare provider, is often frustrated about what do we do next and how do we ensure that our rights are protected and that we still have access to this very basic medical procedure. And one of the things I want to bring in is that what we need to do is to continue to pressure our politicians to make good policy. So the courts of law are not the only places for us to be involved and to push for changes. One of the things I can say is that the Washington legislative session, this session, passed 4 bills that are part of a protective reproductive rights package. And that was due to pressure from community members, from folks on the ground, letting our legislators know that this is a priority. So that is an important component of this, is that we should all be legislatively engaged and engaged in policy processes outside of these courts of law as well, because those also indicate to judges that these are popular and that if the legislature is passing these sorts of laws, these are things that they should also be paying attention to. So I want to also add that component in, is that we do need to all be actively engaged and be engaged on the grassroots level in supporting reproductive rights and reproductive justice, both in our local communities, on the state level, and even on the federal level. And then I just also want to flag, I did see the comment from Jamie that SCOTUS delayed the decision until Friday. So just wanted to say that out loud for everyone as well.
Thank you so much for bringing that perspective in, Alizeh. It's important to know there's multiple avenues for folks to get involved so that their voices be heard, that folks can look to get involved with. So thank you. I'm not seeing any comments on Facebook, and I'm not seeing any more questions in here. So I think we can probably move to close our conversation for today. We do have a time restraint, so we do have a hard cutoff here coming up anyways. But I did want to remind folks that if you are looking to get more information specifically on what Legal Voice did with regards to reproductive access in Idaho and also in Washington State, we have 2 legislative debrief Zoom events that you can participate in that are coming up. And we just posted the information in the chat. I'll also make sure we get this on our Facebook Live. But the Idaho legislative session debrief is taking place on May 4th. It's 6 p.m. Mountain Time, 5 p.m. Pacific Time, and you can RSVP to join in, ask questions, get information on how you can get involved if you live in Idaho, or if you just want to support the folks in Idaho, like let them know they're not alone in this fight to maintain reproductive access. You can join us there. We also have the Washington legislative session debrief on May 11th, a week after, at 5:30 p.m. Pacific Time, and we'll have the Zoom link available for you to RSVP as well. And as Alizeh mentioned, we were in coalition with multiple other organizations, and 4 of those reproductive justice bills got passed, and we're just waiting for governor's signature on those. So we'll provide more information specifically on what those bills do, what they're going to do, and why it was needed. Sneak preview, direct response to states like Idaho restricting access for folks, and those folks looking for states to be able to access the essential health care that is needed. So thank you so much for your time today. Julia, Alizeh, is there anything that you want to leave folks with at all before we close out today?
Thank you all for being so engaged. We really appreciate you being here, and I hope that we can see you again at our different leg debriefs or other Legal Voice events.
Yeah, thank you all.
Thank you. We'll follow up with the links in an email, so stay tuned. And thank you so much for joining us today. Have a good day, y'all.